everyone, welcome back to Case Closed, the podcast that's here to help you revise the basics of A-level law. In today's episode, we're asking court or compromise. Should a legal dispute go to court or be resolved through ADR? Let's break down the advantages and disadvantages of both routes. Let's start with the civil courts. First off, judges are highly experienced legal professionals. Whether it's county court or high court, you'll have a qualified judge handling the case. If something goes wrong, there's a clear and structured appeals process, whether it's the decision or the amount of compensation. Civil courts also offer open justice. The press and public can attend, which adds transparency and accountability. However, if you lose, you pay the winner's costs and your own. That can easily add up to more than your actual claim. Delays are common. Even with the track system, getting to court takes time. And unless it's a small claim, legal representation is pretty much essential, which adds even more to cost and complexity. Let's have a look at ADR overall, and then we'll break down the individual types. So generally, ADR is far less formal than court, no wigs and no gowns. ADR is often quicker, easier to arrange and usually private. Plus, solutions can be based on common sense, not just the strict letter of the law. However, compensation is usually lower than what a court might award. There's no public funding, so an unrepresented claimant might be up against a lawyered up business, and appeals, very limited. You need a lawyer, and that means more cost. Now let's take a look at the four main types of ADR. Negotiation is often free, no lawyers needed. The parties are in full control and it helps to preserve relationships, especially in personal or business disputes. However, it only works if both sides are willing to negotiate. If one party is hostile or uncooperative, negotiations simply won't work. Sometimes going to court is the only real option. Conciliation, it's much cheaper than court. The parties can choose the conciliator and have control over the process. Plus, it can help maintain future business relationships. However, a conciliator might pressure the parties to agree. There's no guarantee of a resolution and the result may not be binding. Moving over to mediation, like conciliation, it is cheaper and less formal than court. The parties stay in control and can maintain positive relationships. This form of ADR is common in family and workplace disputes, but it only works if both parties are willing. There is no guarantee of reaching a settlement, and again, the outcome may not be legally binding. Finally, arbitration. An arbitrator is qualified and experienced in the relevant area. It's often cheaper than court, and the decision or award is final, binding and enforceable. However, it is the more formal and expensive form of ADR and is not suitable if the dispute involves complex legal issues. So what's the takeaway? Civil courts offer structure, qualified judges and enforceable decisions, but at a cost. ADR is quicker, cheaper and more flexible, but less certain and harder to appeal. Each method has its place, and understanding the pros and cons helps you advise your client on the best path for a civil dispute. Thanks for listening to Case Closed, and follow us on TikTok and Instagram. See you next time.